Afternoon. Welcome back to July 7th, 2026 afternoon Lane County Board of Commissioners meetings. I see we have Norrie and Lindsay up here. Next on our agenda is Planning Action File Number 509 PA2405360. The title for this item is as follows. In the matter of reviewing the hearing's official decision affirming the planning director's denial of a non-farm dwelling on non-high value soils proposal in the exclusive farm use zone E30 pursuant to Lane Code 16212-3-2.6 Assessors Map 170130 Tax Lot 2000 File number 509 PA2405360. This matter involves a quasi-judicial decision by the Lane County hearings official affirming the planning director's denial of a non-farm dwelling on non-high value soils proposal in the exclusive farm use zone. The planning director requested board review pursuant to Lane Code 1408005. The board opted to review the matter and held a de novo hearing on May 12, 2026. Staff presented the staff report at the hearing and answered questions posed by the board, but there was insufficient time afterwards for the rest of the proceedings. On May 12, 2026, the board chose to continue the de novo hearing and directed staff to return on July 7th, 2026, today at 1:30 p.m. to continue the hearing. The order of proceedings today will begin with a brief overview by staff of the May 12th hearing, followed by the applicant's testimony, then testimony by persons in favor of the application, then persons who are neutral, and finally by persons that are in opposition to the application. After that, staff will have an opportunity to present any further comments or information in response to the testimony and evidence. And then finally, the applicant will have the opportunity for final rebuttal. The board's decision will be the final local decision, appealable to the Land Use Board of Appeals. Okay, at this time, commissioners must disclose any ex parte communication. If any commissioner has received any ex parte communication, then please, for the record, disclose the substance, circumstance, and parties to such communication, and state whether you can render a fair and impartial decision.
Mr. Chair, if I could clarify, because I probably should have intervened there.
Yeah, please.
We've already done this before, as you may recall, in May, so really we're focusing in on anything that might have happened since that time in terms of the next three things you're going to read. So I'd like folks to focus on that, if there's any disclosures since
from
last
May
time.
12th on?
Yes.
Great point, Council Bovet. Thank you. Okay, with that, Commissioner Lovell.
None to declaring, and I can be impartial.
Commissioner Farr?
I have none.
Vice Chair?
None.
And I also have none. Now I will ask commissioners to disclose any personal knowledge, bias, prejudgment, or conflicts of interest related to the matter before the board. Does any commissioner need to disclose personal knowledge, bias, prejudgment, or conflict of interest? Commissioner Lovell?
None.
Commissioner Farr?
I have none.
Vice Chair?
None.
Okay, and I have none. Now I'll ask commissioners to state whether there are any abstentions due to any of the conflicts or biases stated. We have none. Okay, the applicant and those in attendance are allowed at this point to challenge disclosures and to challenge the qualification of any commissioner based on bias, prejudgment, or conflict of interest. Challenges will be limited to 3 minutes, and please be sure to state your name and mailing address. Does anyone challenge commissioners' disclosure or qualifications? Seeing none. Ms. Spalding, would you please introduce the documents before us and then provide the staff overview of the prior proceedings?
Thank you. This is Norrie Spradling, Senior Planner staff processing this application for Lane County. This is going to be just a brief overview. On the last meeting that we had, we only had time for the staff presentation where we talked about the location of the property there along the McKenzie River, and it's in a fairly rural neighborhood with only some residential use occurring on to the northeast, and the rest of the properties in the surrounding area are mostly exclusive farm use zone and undeveloped. I presented the hearings official's decision on the matter, going over how the hearings official agreed with the planning director's denial based on 3 matters. One was that the planning director found that the development had occurred in the riparian setback area, that the development did not meet the Chapter 15 standards for transportation access, and that the development in this location did not meet the minimum density standards for peripheral big game habitat in Goal 5. From there, questions were answered by the commissioners, but we ran out of time. So at this point, we can proceed with the rest of the proceedings.
Okay, thank you. Before we move on, any questions for Ms. Spalding? Okay, seeing none. Now the applicant or applicant's representatives may provide their presentation to the board. Please be sure to state your name and mailing address for the record.
Good afternoon, Chair Senega, Commissioners, Commissioner Buck online. Good to see all of you here today. My name for the record is Mike Reeder. My address is 375 West 4th Avenue, Suite 205 in Eugene. I represent the applicant, Kathleen Jones McCann, and I'm here to present our case in chief and also to respond to any questions that the commissioners may have and to rebut any evidence and testimony that's received today. Before I do that, I'd like to introduce the applicant team with me today, representing the applicant regarding the wetlands pond issue is Brian Meyring of Wetlands and Wildlife. He is a biologist. His resume is in the record, and he's available to answer any questions that the commissioners may have. His written testimony is here before you, so if you have any questions about his written testimony, he's able to respond to that today, should you have questions. What I'm going to do is I'm going to turn over a couple of minutes to my client, the applicant, Kathy Jones McCann, who would like to say a few words. After she says a few words, then I will get back up and I will present our case in chief. So,
Okay,
thank you.
thank you. Ms. McCann.
I am so glad to see you gentlemen here and finally meet you, and I appreciate this opportunity to talk to you, because I think that what is going on at Lane County with staff and with Land Watch is abhorrent, and we need representation. The people of Lane County need representation from people that care about the people. And so there's a few things I'd like to clear up. It's absolutely horrific to read lies and fabrications from people who have just seemed to want to wage a vendetta. And apparently, especially against me, because I can afford to fight. And it's what most people can't. And this wonderful man that is typically representing people with all kinds of land use problems costs a freaking fortune. And most people cannot afford to stay the fight that Lane County wages and lets it go on and on and on. We are 2 years in this battle. And I don't know anyone who could afforded to keep this up. And people are upset with me, maybe a few, because, oh, she's wealthy and so she's just going to get her way. Oh, no, please give me a break. First of all, I'd like to say that when I started building this building, which is about 50 yards from my home, and a one-room cabin that I built, it was a wood storage shed, cement floor, 12 by 20 with 4 posts and a roof. And I decided, oh my God, I'll put walls around this and be able to sleep in it while I redo my home, remodel my home, which is a 2-bedroom home. It's the size of a double-wide manufactured home up on stilts. I've read all kinds of things that say, oh, she lives in a great big huge mansion and she's got all this money and she comes from a timber family, and all of this is just, to me, to violate my sense of self and to perpetrate this incredible biased smokescreen. I'm just a person that happens to own some property that wanted to build a shop on it. But when I started this, got this idea to do it, it was the beginning of COVID, and we went down to the permitting offices, closed to the public. We went back 2 weeks later, closed to the public. I gave up. I had a friend there who's in construction, and he said, you know what, take pictures of everything inside this construction, take pictures as we go. You can turn it over to inspectors, they can approve it, everything will be to code. I said, perfect, let's do it. It took forever to build this building. It's 40 feet wide and 90 feet long. It's a 6-bay shop. It's got big garage doors. It had to be 2 stories because I wanted my motorhome to be able to fit in the end slot, which is a 16-foot high door. So we built this monstrosity, which is virtually twice as big as my home, and we're getting into COVID, and I started realizing that if this doesn't end, or there's other government calamities, I could be housing my kids and my grandkids. My granddaughter gave me a sign, my biggest fans call me Nana. I am a recluse, absolutely, from the word go. I have been my whole life, to my own detriment at times. My children and my grandchildren are the love of my life. So I'm thinking, how can I bring them all here? How can I keep them here and keep them safe? And I put in a new well with actually a hand pump on it. And I put in solar panels in case all the electricity went out. And I designed that shop to be basically bulletproof, where I could house my kids and my grandkids and keep them fed. And we went and we gathered food stores. I've got enough food to feed half of Eugene stored in that shop. So what happened then is very strange, because a neighbor wanted me to buy a lot that he had nothing on, that comes up against my property and is next to the lot that his house is on. And I did not want to buy it. And he came into the county and found out that he could not get a permit to build on that lot as he had wanted to. He wanted me to buy it so I could eventually build or keep it as a buffer. I didn't want it. But he didn't find out that he couldn't build on it because of some kind of wetlands or whatever else. He found out he couldn't build on it because this small little clutch of a handful of people had decided behind closed doors that they were going to disallow permits on any parcel in the McKenzie River corridor that hadn't previously been permitted. And unfortunately, as close as my house is to my shop, my land goes like a big fan. And my 3 buildings on my property are back on this tiny, narrow point back here, which is also the highest point. And that front part of the fan is where the McKenzie River runs. I'm over a quarter of a mile from the river, and I'm in a higher plain area. So I've got my small house, my 1-room cabin, and my 40 by 90 foot shop there. Now, it drops downhill right behind these buildings. It drops downhill probably 12 feet, and there is some water that pools back in there. It used to come from the river, but the river used to come way downstream, come up, and come in. It does not any longer, and I've lived there for 20 years, and it never has. And one of the main reasons is because if you continue east on Heather, which runs east and west, you pass my driveway and go to the end. The house down at the end had apparently the Corps of Engineers put 4 huge 8 to 10 foot high slabs of rock on the embankment in front of their house and caused that river to ricochet south We're on the north bank. It ricocheted south so much it took out a farmhouse on the south bank, right across from my property. So we had, white PVC pipes sticking out of that. The front porch, the front porch went downstream, and they ended up having to demolish that house. That's how much that river's moved. And whereas when I first moved in, there was just a thread of river rock, and then I accessed about 1/4 of a mile by foot of the McKenzie River, which I absolutely love. It is why I bought the property. It is my absolute joy and passion. And they tell me that I have the longest stretch of accessible river frontage on the river. And I cherish it, and I cherish all of my property. So back here in this area, back on this little point, they have now decided that this puddle, and this gentleman is here to attest to this, is some kind of Class 1 stream. And they absolutely refuse to listen to Mike when he tells them, no, it isn't. So I hope that you can trust what has been said. Also, I've just recently received a letter from Keir Miller saying, we have it by reputable sources that your house is unsafe, or that this dwelling, this shop is unsafe. We need you to get everything out of it. I do tend to believe that those reputable sources are the neighbors. And the fact is that 2 years ago, Mike had a structural engineer come in and go through that entire shop as if I would build anything that was not to code or structurally sound, and testified that and signed off that it is permittable and structurally sound. So there is no reason to issue these permits, not environmentally, which is the hammer they love to use, and not structurally. But this is a game of control. Lane County is into massive control of people's property. And I didn't realize it. No one realizes it, because you're just living your life, especially rural property owners. We're just out in the country somewhere and we enjoy our peace and quiet. I've got more animals and birds and everything from foxes that we've just now, Peter was telling me, my son was telling me, we've got a muskrat in our pond. Now, these are man-made ponds, by the way, that were made before I came. So this whole thing of environmental, oh, there's a stream, oh, there's something natural, oh, you've got to stay 75 feet away. I could list right now more animals and birds and that come back and stay on my property because of those man-made ponds, the pastures, the woods, everything that I love about this property. There is no environmental instability because of anything that I'm doing there. But this idea that they can hit you over the head with environmental issue and say you can't get your permits, well, I think that they're really scared at this point. I think Sean Malone and the county staff are scared because you people are listening. And I will tell you that we formed now a 501c3 to combat Land Watch. And it is to help the people of Lane County reach their goals and have the support they need, legally and otherwise, to surmount all of these property issues. And that's called ROPA, R-O-P-A, Rural Oregon Property Advocates. And I will tell you the simple story, and then I will step down, of what got me deciding to do this. Was a couple whose attorney called Mike Reeder when I had just begun this 2-year gauntlet and said, I hear what you're doing for a client of yours, and she has the means to see this through, and I want to explain to you, I have a client and I'm hoping you can help them, and maybe she would be willing to help them. A couple going to retire, 10 years before retirement, they lived here in Eugene, always had lived in town, and they had decided that they wanted to retire in the country someday. This was their dream. So they found 10 acres just outside of Cresswell. And this filled them with a passion. So the clock ticks by, they save up their money, they get ready to sell their house in Eugene, they retire, and they come to Lane County to get their permit to build? No. No. We're not giving it to you. Can you imagine being in that position? Retired, a couple, your dream just vanquished, not to mention your property is now worthless. So I looked at Mike, he looked at me, I said, do anything you can for them. This is atrocious. This is why I'm up here speaking right now. And I'm so grateful that you are here listening, because what is happening to me is an affront, and it's a battle, and they want to see me cave, but I won't. And I am going to go right on and help people in this county every way I possibly can, and this man is dedicated to it. And so thank you. Thank you for listening to me. I appreciate it.
Thank you, Kathy. Again, for the record, Mike Reeder representing the applicant. You've received quite a bit of material. You received it before the May 12th initial hearing. You've received additional material today. I apologize. We received some information late, so we wanted to respond to that to be as expeditious as possible. So what I'd like to do today is I would like to go through the 3 appeal issues and add a 4th. And I'm going to be as brief as I can, because I expect that there's going to be quite a bit of testimony that we're going to need to respond to. But first, I know that we had this initial hearing, and we had a staff report, and we had some commissioners have some questions, and I'm happy to entertain questions now, or during my presentation, or after. So if any commissioners have any questions now that you think might be appropriate to ask, I'm happy to answer those. Okay, so first of all, I want to clear the record. We have asked that this hearings official's decision be reviewed by the board under the county code, and we initially asked for that through the then planning director, Amber Bell, back in August. And back in August, she did so. In August, I provided the board with my Me Too letter, basically explaining why this issue has countywide significance and to request that the board review it. Now, I want to talk about this a little bit because there's been a lot in the press. There was a lot at the May 12th hearing about your responsibilities in a quasi-judicial situation. This is quasi-judicial. It's not judicial. In other words, as elected officials, you have the ability to make statements and to have positions that are political regarding land use. You can be pro-property rights, you can be pro-environment, however people want to label you, you can do that. And often that's how people are elected to positions such as the Board of Commissioners, or in the case of City Council or the state legislature. The applicant did not seek review of this application solely for herself. And she did not seek review of this application during the campaign season. She sought it back in August. And after August, after Planning Director Bell requested review of this, we didn't hear anything. So I contacted her and I asked, where are we on this? And it wasn't until May that we came before the Board of Commissioners. So we wanted to get to before the Board of Commissioners before election season. And I just want to lay that down because I think there's a false, if you read the media reports, there may be an insinuation that there's a quid pro quo, that my client donating to campaigns somehow was meant to get a positive result here, and that is the furthest thing from the truth. My client has the right to participate in elections when and how she wishes. She also has a First Amendment right to come before this board and seek redress on an issue that's unrelated to the campaign. So whatever narrative is swirling out there needs to be batted down, and we need to understand that people have First Amendment rights. And you as elected officials have the right to receive help in your campaigns. That's how democracy works. So we don't give up one right to exercise our First Amendment rights in order to exercise our other First Amendment rights. That's not how it works. Now, in regards to the concern about the fact that this was an unpermitted dwelling, yes, there is no secret that my client did not obtain land use and building permits before she constructed this dwelling. She received a notice from the county, and that's when my client contacted me, like dozens and dozens of other clients of mine who are not in the news and who are not of means, who, for one reason or another, build without obtaining approval. Now, what's the remedy for that? Well, the remedy is, what typically happens is the applicant, the person who built without permits, goes to the county, says, yep, I did it. Here's how we're going to solve the problem. So what I did on behalf of my client is I provided Lane County code compliance officials with a roadmap to how we can get this permitted. Okay, so when an application for a dwelling or any other unpermitted structure is made, you as an applicant, you pay double the building permits, whether you're a mom and pop, whether you're Jones McCann, that's what happens. And you go through the process. So we obtain the services of a structural engineer to come look at the building that was built without permits, and he signed off, he stamped it with his stamp and said, yes, this is well constructed, this meets code. So then what do we have to do? Well, we met with county staff and we said, look, we will go through the process of obtaining land use approval, and then once we receive land use approval, we can then obtain building permits and move forward so that everything can be above board. So we did that. We're going through that process, and in that process, we get these stumbling blocks. And those stumbling blocks are the issues that are before you today. The first one is, which predates my client seeking to obtain approval from the county, was that the Board of Commissioners, most of you are not on this board, adopted an ordinance that we've talked about before that prohibit all new construction in the floodway. And there's no exception except for arguably a variance exception, a variance process, which another client of mine has tried to go through and has received a denial from the hearings official. So this floodway prohibition that was adopted by your predecessors took away the right of my client to obtain land use approval for a non-farm dwelling in the floodway. So her property is entirely within the floodway. Her single-family dwelling, so she owns 2 lots. The first lot is developed with a single-family home that she talked about today, which met the criteria for approval for a non-farm dwelling and a dwelling in the floodway. And that was done back in the 80s, and it was done when there was not an outright prohibition. If you wanted to build in the floodway, you had to go through the floodway process. You had to make sure it was engineered. You had to make sure that there was no net rise, that there wouldn't be an impact in a 100-year flood. And that's what happened. That's the house that she lives in now. It's fully permitted. But since then, she purchased the property to the north, which is where she built the illegal building. Okay, that's subject to the non-farm dwelling application today. So there's the non-farm dwelling application criteria that we believe she meets, and there's 3 reasons why the hearings official said she didn't meet them that we're going to talk about today. And then there's this other issue, which is a total take. So during COVID, the County Board of Commissioners adopted an ordinance that said you can't build in the floodway there's no exception except perhaps for a variance. So my client's property is fully within the floodway. There are many others, perhaps 140 other properties in Lane County that are vacant, that are fully within the floodway, that are prohibited from building a dwelling. Now, to be clear, some of those properties may never be able to qualify for a dwelling because they may not meet the criteria for a farm dwelling, a non-farm dwelling, or a farm dwelling, or a forest template dwelling, or any other type of dwelling that is allowed in the county. But there are other properties that are vacant that do qualify for either a non-farm dwelling or another type of dwelling that are right now prohibited from only because they are entirely within the floodway. And that is a total taking under the U.S. Supreme Court case of Lucas versus South Carolina Coastal Council. In the 1980s in South Carolina, a developer wanted to develop a barrier island with single-family housing. And at that time, the rules allowed for single-family housing. Lucas had one or two lots left that weren't developed with housing. He wanted to do it in 1988 or 1986 and 1988. The state of South Carolina adopted the Beaches Act, meant to protect the island from erosion, and they had this goal, this environmental goal of protecting the environment. And Lucas had the temerity to challenge this and said, hey, look, this is a total taking. This is a total regulatory taking of my property. There's no value left in my property. There's nothing that I can do to it. And he had to go to the U.S. Supreme Court for the U.S. Supreme Court to say that the Fifth Amendment to the Constitution doesn't allow the government to take all economic value from a property. And the South Carolina said, well, you can camp on the property, or you can fly a kite, you can look for you can bird watch, you can camp, but you can't have a dwelling. And the U.S. Supreme Court said no. If you can't farm it or forest, do commercial forestry or any other type of economically beneficial use of your property, including having a dwelling, then that is a total take, meaning the state has to compensate you for that. And that's what happened. The state of South Carolina paid for those lots that eventually sold it and it was developed today. So that is very similar to what has happened here. My client's property has no economically beneficial use if she can't put a dwelling on it because it meets the non-farm dwelling criteria. It cannot be farmed. It cannot be used for commercial forestry. The only economically beneficial use of this property is for a dwelling, and that's what she's seeking. So that's issue number 4 today that I wanted to jump to kind of present in context what's going on. So Chief Justice Roberts of the U.S. Supreme Court said that if citizens are required to square corners, or basically do the right thing and get your permits and do all those things, then the government must also square corners. And in this case, we have 2 things going on. We have someone who didn't get the permits that she needed. She owns that, and that's why we're here today. But then also the Board of Commissioners back in 2001 took away her property rights. So we're here today to merge these 2 issues together, to go through the process that Lane County has for everyone else, which is to receive permits after the fact, and also to receive a waiver of that outright prohibition of no new construction in the floodway. Okay, so that's the ask for today. So what I want to talk about today is Ciporin. So Ciporin is the Oregon Supreme Court case that says that when a local government elected body, the governing body, which you are, interprets their own ordinance, then that interpretation receives what we call Ciporin deference, or basically LUBA says, look, essentially LUBA says, we didn't adopt this ordinance, you did, so we're going to defer to your reasonable interpretation. We may think our interpretation is better, but we're going to defer to the Board of Commissioners. So you have the opportunity as a board to interpret your ordinance in 4 ways. And the first one is whether the improvements on the property are within the riparian setback. Does your rural comprehensive plan mapping identify the location that staff and Joe Stack from the Oregon Department of Fish and Wildlife believes is the riparian area? Or do you look at your adopted maps, the maps that were adopted through your comprehensive planning process for the protection of Goal 5 resources? Do you look at those maps? Okay, that's the first issue. The second is does the rural comprehensive plan Goal 5, Policy 11, big game range, impose a minimum density or minimum lot size on this exclusive farm use property? The answer is no. Okay, the hearings official said yes. The hearings official went along, in this particular case, went along with what staff has argued. The third appeal issue is whether the roads standards of Lane Code Chapter 15 may be applied to a land use decision such as a non-farm dwelling. And can that be a reason for denial? And the answer to that question is no. And the reason why that is because Lane Code Chapter 15 was not adopted and acknowledged pursuant to the statewide planning system. In order to impose standards and criteria for a non-farm dwelling through the land use process, the standards and criteria must be not only adopted by the Board of Commissioners, which Chapter 15 was, but it must be acknowledged as a land use law through the state. Okay? You do that with all sorts of land use ordinances. Whenever you change the the floodplain regulations or the amendments to the code that we've recently talked about here in the last year or so, you have to go to the state to get approval. When you don't do that, when you simply adopt standards pursuant to your procedures and you don't go through the acknowledgement process, you are prohibited by law from applying those standards and using those standards as a reason for to deny. And that's what the hearings official did in this case impermissibly. He applied Lane Code Chapter 15 road standards and said, because you don't meet those standards, then you are not allowed to have your non-farm dwelling. So I'm going to start with the easiest one first, the third one, the road standards. This one's easy. We've asked staff, there's no acknowledgement process for Lane Code Chapter 15. So you might want to take a look at that in the future if you want to use that as a reason for reviewing land use applications. But perhaps more to the point, more importantly, is that the access to property is in and of itself a property right. If you don't have access to if you don't have vehicular access to your property is usually valueless. People aren't coming in with, on hot air balloons or helicopters or airplanes, okay? The property's not that large. You have to have vehicular access. My client has legal access. That legal access staff doesn't like because it'll require a bridge that will go over a pond or wetlands, okay? Well, there are ways to get DSL and Army Corps of Engineers approval to go over wetlands. You can actually avoid them with bridges. And my client has shown that she has the ability to do that it's feasible for her to do that. And the hearings official got that wrong. Do any commissioners have any questions about the roads issue?
My only question was, what was the hearings official basis? I mean, he's obviously not a bridge engineer. He's a hearings official.
I believe his basis for denial was, well, I'd have to go and look at his precise language, and I don't have that off the tip of my tongue. I'd have to look at that. I don't recall because it was pretty weak.
No, you're clear, thanks.
It was hard to understand. So, but our engineer, Kevin McCormick of Miller Consulting, he provided a feasibility study on June 2nd, 2025, indicating that it was feasible to put the bridge over the wetlands. Now, I have to admit that this kept me up at night. Before we engaged a structural engineer, I was thinking to myself, how do we avoid the wetlands? I'm not an engineer. How do we do this? And so when we engaged Kevin McCormick, and he said, yeah, there's a way to do it. It's easy. And we've got that information into the record. So why the hearings official didn't accept that evidence, I'm not sure. Okay. Okay, so let's talk about the next, I think, is the easiest appeal issue, which is flora and fauna, Goal 5, Policy 11. I'm struggling with this, commissioners. I reviewed the June 12th, I think it was June 12th, 2023 meeting where this board had a discussion, a lengthy discussion with staff about big game, about Goal 5, Policy 11. And in that case, you were talking about its applicability in the forest zone, and you instructed staff to bring forward the next relevant application regarding Goal 5, Policy 11. And we are still waiting for a final decision on your oral approval of the findings in that Ed King case. And what I'm struggling with is I'm struggling to understand why staff would assert that Goal 5, Policy 11 would apply in the EFU zone if you as a board have already interpreted your land use regulations to say that it doesn't apply in the forest zone. I can't figure it out. I don't understand the rationale. It makes no sense to me. But in any case, they're wrong. Goal 5, Policy 11 doesn't apply in the forest zone and doesn't apply in the EFU zone. And I've provided you today with some legalese, some analysis of case law, Oregon case law. One of the first LUBA decisions, the second year LUBA was in existence, LUBA held that when people cannot understand a land use regulation, it's invalid. Your authority to regulate land use comes from the same authority that police officers use to enforce any criminal law. It's called the police power. So when you sit in judgment on this, you are exercising police power similar to a police officer. There's a famous saying, I think it might have been Holmes, a Supreme Court justice, who said that if a police officer needs to understand the Constitution, so does a planner. And that's the case here, is that you need to understand that in order for a land use regulation to be valid, it has to be understandable. And that comes from not just from Justice Holmes, but it comes from Oregon Supreme Court case law. And I've provided that to you in my hearing letter today. So from 1984 to I think 2021, Lane County had never applied this policy to a discrete land use application. Think about that for a minute. 1984. I think it was in elementary school. And then all of a sudden in 2021, oh boy, somebody found a policy that applies to a forest template dwelling. You've got to have, if you've got peripheral big game range mapped on your property, you've got to have 40 acres. If you've got major, then you've got to have 80 acres. Well, for forest template dwellings, many, if not most, parcels that qualify for a forest template dwelling don't meet that size, okay? Well, protecting big game range habitat in forest areas may make sense, but it's certainly less of an issue in EFU zones, in farm zones. Okay, there's better, I'm not a biologist, but there's better habitat in the forest for big game range than there is on EFU, and fewer conflicts. So why it was applied in this case is it just blows my mind. I cannot understand it. Yeah, that was a huge error. And the fact that for 40-something odd years, this policy had never been applied means the application is suspect. And I wasn't involved in NMCISH. I wasn't involved in King, but if I was, I would have made this argument that that interpretation is invalid on its face simply because for decades it had never been interpreted that way. And there's no way that you can expect a property owner to understand that there's this density requirement on their property. It's absolute foolishness. And I provided you the case law that backs that up. Any questions about big game range? Oh, I mean, I guess I would just add or emphasize. And then once you as a board made your oral decision in the King case that it doesn't apply, and for the reasons that you are going to adopt when the findings are before you, that same rationale would apply to EFU property. Because back in the 80s, when ODF and W was giving recommendations to Lane County on their Goal 5 flora and fauna, their working paper, their recommendation was based on forest and EFU. It wasn't just forest. So the fact that the recommendation was rejected by you in your interpretation under the King application, that same rationale applies to EFU, if not more strongly. Okay, let's talk about the pond. Everybody knows that rivers and streams will move on occasion. The McKenzie River, for sure. And this is the difficulty that planning can have. Statewide Planning Goal 5 requires that when a local government wants to protect Goal 5 resources, whether they be aggregate, whether they be wetlands, whether they be streams and rivers, big game range, that those things that you want to protect, they must be inventoried. And when you inventory something, you have to identify it. It has to be discernible. And usually that's a list. Lane County could have had a list of all the rivers, all the streams. What they did was they adopted a map, and back in the 80s, they used markers. We didn't have GIS, okay? Go back in the Wayback Machine, remember what we were working with, Xerox and Sharpies. And they took a map, and they did, and back then in the 80s, they used a marker to determine which Class 1 streams, as defined by the code, which Class 1, and by the comprehensive plan, which Class 1 streams were going to be designated as Class 1 streams for protection under Goal 5. And so when you look at the map of these streams in this area, you see that there are thick black lines that extend along the main body of where the McKenzie River used to be, and it's moved, especially on my client's property since then. And then there are certain streams where the black Sharpie ends. So if you look on the map, you can see a stream, and then you can see the Sharpie, and it ends. And there's portions of that stream that are not, it's not, that black Sharpie didn't continue. At the very least, Lane County did not identify certain portions of Class 1 streams as designated for protection under Goal 5. And Tom Lanphier, who works for me in this application, who was there in the 80s when this happened, he has told me, and we have that evidence in the record, that that's how it was done. Now, there's some evidence that you received today, or maybe yesterday, in the record that suggests that back in, it would have been the 90s, 1995, that a planner, Bill Sage, had made the jump that, hey, because there's a reclassification of the streams from Class 1 to Class F under the Oregon State classification system, that somehow those Class 1 streams that were identified on Sharpie on those maps, well, that's now you have to look at these Class F streams, and those Class F streams are subject to the riparian setback. But then what you didn't have, what I provided to you in the record, is 12 days later, Bill Sage going back, telling his colleagues, wait, whoops, I got it wrong. In order to change the maps, the inventory, if you will, You have to go through the public process. You have to go through the planning process. You have to have a public hearing with the Planning Commission and with the Board of Commissioners to change those maps. Even if, and this is my editorialization, even if those rivers and streams move, okay? So what we did was, in this application, we realized that when you look at the map, and I provided those to you in the record, when you look at the map, the class 1 stream that is identified in those planning documents is now no longer, it's no longer a stream on my client's property. It's just dry, old riverbed. But the map still shows that it's protected. And so what we did as the applicant was we said, hey, we invited staff out to the property and said, look, we're doing a riparian declaration. We want you to eyeball where the class 1 stream is as identified, designated on the comprehensive plan map, and then pace out 100 feet to show that we don't violate the riparian setbacks. And we thought that they were going to go where the map was, but instead they went to the pond. And they said this pond is an extension of the backwater of the McKenzie River, and it's protected by Goal 5. And we said, no, it's not. It's not on the map. And by the way, then there's secondary reasons. It's not connected hydrologically, and the state doesn't claim ownership of it, and we gave them all of these reasons why not. But they are stuck on this, and you heard it back in May from the staff report that this pond is somehow part of the McKenzie River. We don't believe that it is. We have evidence in the record from a biologist saying it's not. But even if it is, it does not matter because your comprehensive plan documents do not identify it as protection under Goal 5. Furthermore, the case law that I've provided to you says, it basically addresses this issue of when you have maps with a squiggly line that are imperceptible. They have, if you're going to regulate land use and you're going to prohibit somebody's use on their property, you better have a fixed determination of where those lines are. You can't guess. Now, I know a lot of jurisdictions, Eugene's got a comprehensive plan blob map. It's not very precise, and they do also, I spend lots of time working with clients on the blob map. But the fact of the matter is that the case law said you've got to be definite. You can't leave it up to guesswork. It's not done on an ad hoc basis. We invited staff who brought ODF and W out onto the property to do a tape measure of the designated mapped class 1 stream that's no longer even a stream. They didn't do that. Instead of going to the west, they went into the east where the pond is. And they said, well, and now you have evidence into the record from Mr. Stack that, well, there's fish in this pond. Okay, well, that doesn't have anything to do with whether or not the 100-foot setback for EFU property is applicable. It has nothing to do with it. It may be desirable. If you're ODF and W, you may want 100, you might want a 1,000-foot setback from a pond. And even if the property is hydrologically linked, it still doesn't move the dial legally. One more thing to consider when it comes to the pond and the setback. Across the pond, adjacent to my client's property, are rural residential dwellings. They are subject to a 50-foot setback for the exact same pond. Why? Well, the answer is because they're rural residential, and you're EFU. Biologically, what difference does that make? Do the flora and fauna care that we have put a map on rural residential property and a map on EFU property? No, they don't. So in order to, as applied, apply this arbitrary standard, you've got to ask yourself, does this make sense? Is there a planning reason in this particular case, not generally, not legislatively, but in this particular case, is there a planning reason why we give those guys 50 feet, but you're subject to 100 feet? Now, the easy answer, the devil's advocate answer is, well, you got to draw the line somewhere, and I agree with that. You do have to draw the line somewhere. But when you sit in your quasi-judicial position and you ask yourself, does it make sense? Is there a valid purpose in this case? That's when you have the ability to say, no, not in this case. So there's legal reasons why ODF&W and staff are incorrect, why the hearings official was incorrect to determine that the pond was designated as a Class 1 stream that subjected my client's property to a 100-foot setback, at least for that pond. Still subject to the one where there's dry riverbed, be that as it may. But you have to apply the Constitution, okay? So even though on the face of the ordinance it says 100 feet, in this particular case it makes no sense. Now, the other issue regarding the 100-foot setback is this. The building has been built, but the 100-foot setback, that's not a reason to deny the forest template, I'm sorry, the non-farm dwelling application, because it's feasible to build a dwelling on the property. It might not be this dwelling if you agree with ODF&W and staff, but it doesn't mean you can't have a dwelling on the property at all as long as you meet the setbacks. So it was error for the hearings official to deny the application on that alone. Okay, it may not help my client in this particular case where she's already built a building, but certainly it wasn't a reason for denial and it should fail for that reason in particular. Staff provided you with a map that purports to show the mapped, okay, so think about this for a second. The Rural Comprehensive Plan map, where I was talking about the Sharpie, staff, I don't know what they did, but they have a map in the record that shows the subject property as being basically the designated goal 5 riparian, the Class 1 stream going through the property. That map is in error. I'm not sure where that came from. We have in the record, using the county's GIS, and I provided it to you in today. If you flip to it, this is important because I'm getting the skeptical look from staff. If you look at the first map, it's attachment A to the staff report. So my letter dated July 7th. There is, for your convenience, looks like this. This map, I believe, was produced by staff. So where it says subject property, that's not from the applicant. I believe that's from staff. And it shows, if you've got your reading glasses on or a magnifying glass, you can see that they have attempted to identify the location of the subject property in red. And you see the big black line going right through where my client has built the dwelling that is subject to this application. This map is in error. I've provided you with the actual county GIS. If you go to the applicant maps of the subject property, exhibits C, E, and L, and this was already in the record, but I'm providing it to you for your. So the first one is exhibit C, and it shows a 2023 aerial, and it shows the location of the subject property in black, and then you see the dwelling there. Unpermitted structure that's close to that little triangular piece of the property. The pond is just to the northeast. To the west, you can't really see it on this aerial, is the dry riverbed. So if you turn the page to the next map, you'll see this is the county's GIS system where they've taken the map and the dashed blue line, that is where the county has identified the Goal 5 Class 1 stream that's designated for protection. Okay? And it goes on the west side of the property. It cuts through the west side of the property. And you can see we've identified where the two structures are there, the cabin that Ms. Jones-McCann talked about, the little thing, and then the dwelling in question is that rectangle there. And you can see that is shown also on RLID. So the next map is Exhibit E. If you look at RLID, it basically confirms what the county's GIS shows. And then also in the record, and I don't have it here, is where we've shown that there is 300 feet from the edge of the designated Goal 5 line here. That's 300 feet to the building. And I apologize, it's not in my material here handy, but it's in the record. Okay, so that's what we wanted staff to do. We wanted staff to go to the location where the mapped Goal 5 resource is. Doesn't matter that it's a dry riverbed. And that may not make sense. You might say, well, why are we protecting it if it's changed? Well, that's the nature and the limitation of planning. And that's why we have periodic review. And that's why we spend so much time and money trying to change the plans, because things change. And the name of the game in zoning is change. There's facts change, values change. And when you want to change your map, you have to go through the SC analysis. You have to go through a public process of balancing and weighing environmental, energy, social, and energy consequences. And you have to weigh and balance them. So if you were going to go through that process and say, hey, we want to protect this pond that, as you will note, is not even located on this county's GIS. You don't even see it there. If we wanted to protect that, you'd have to go through that process. And you would give people the opportunity to weigh in on that and say, okay, there might be fish in that pond, but is it really worth protecting with these setbacks? Maybe it is, maybe it's not. But we're not there yet. We haven't done it. The fact that it may be hard, the fact that it may be expensive, is not relevant to whether or not it's lawful. And I would posit that if it's so important to protect this pond and have a building 100 feet away from the pond, then go through the process of changing that. But that hasn't happened yet. I've provided you with findings, draft findings, that I believe would withstand scrutiny at LUBA and the courts. I'm happy to amend those findings should you approve the application, because we may receive testimony today that might require some changes on those findings. But I would ask that you approve this application and that you direct the applicant to provide findings consistent with your decision that you could then adopt. And I ask that you, as part of your decision, waive the floodway regulation that prohibits entirely new construction in the floodway. And I believe that also would be sustainable at LUBA and the Court of Appeals. If you have any questions now, I'm happy to answer those.
Okay, to the board.
And if you want to wait, that's fine too.
Okay,
Thank you.
thank you. Okay, now parties in favor of the application may provide presentation to the board. Please be sure to state your name and mailing address for the record. Rio, nobody in favor? Thank you. Oh, maybe we signed up on the wrong ones. We can go back there and check. Can we go back there and sign up? Yeah. Miss Ellis, do we have anybody online?
We do. Do you want me to check, see if there's anybody in favor?
Nope, not yet. We'll
Okay.
wait for, I was just curious. Thank you. She'll hand me this sheet and we'll call you up. She'll hand me the sheet and I'll call you up. Yes. Yep.
Karen, how much time should I get a clock ready for?
Well, we didn't set a time. We'll do 3 minutes.
Okay, thank you.
Thank you, Rio. Okay, first up in favor is Casey Roscoe. Yeah, you'll have 3 minutes and the time will start when you state your name at the dais.
Oh, great. Okay. My name is Casey Roscoe. I am so thankful to be here and be heard today. This is so exciting to me. I didn't even know what I was going to say coming in here, but after listening to all of this and really listening to my mom, who is Kathy Jones McCann, I realized that something was missing. Although they covered a lot. They covered the technical aspects of it, which were phenomenal, and Mom's intent during COVID to create something for her family. I would love to take us back there at that time and explain even a little bit more, because in the press, she has largely been vilified, and it's been suggested she was trying to sidestep something. And my experience of my mother is the opposite. During that time, 2020, COVID was coming on, and I'm sure you guys remember we had some wildfires. And I was working for our family company. Mom and my 2 aunts were our bosses. And what's interesting was I have never seen them sidestep anything. My job was to take care of not only our employees, but the community. During COVID, my job was for almost 500 employees. When COVID was coming, we needed to telegraph to them, we got you. No matter what, we've got you. I worked with restaurant supply companies and so forth, and we had a thing where all 500 of our employees got sacks and sacks of groceries when the shelves were empty, everything from toilet paper to soup. And that was Mom and her sisters. When the fires came, my job was to make sure that we could help anybody that needed it. The first thing we did is see if any of our employees had space for livestock, and then put out there that if anybody had livestock that needed to come, we knew where we could take it. The second was we housed anybody that was our employee or a friend or family of that needed the housing during the fires. But then after the fires, I got thousands of dollars of gift certificates from every single restaurant between about Waltersville up to Black Butte. And the reason is because our family knows that those restaurants were the heartbeat of those small communities. They're what make people stop. They're what give people jobs. And they're what people think of when they're going through there, because otherwise they weren't going to stop. It was just all black. And why would you? And so not only did we infuse.
Your time's up, Ms. Roscoe.
Oh, shoot. I'm so sorry. No. Thank you.
It's all right, no problem. Thank you. Next up, we have Peter Gibney.
Hi, I'm Peter Gibney. I'm here on behalf of my mother, I guess, on this whole thing, but I've been part of that property since she purchased it back in early 2000. And it's frustrating to hear this, for me personally, to go through this with her from the emotional side of it, knowing that I've been on that property myself and helped her with that property and seen it change drastically due to the river leaving, going to the south side of the McKenzie as far as it has. There used to be a waterway that came up near the body of the house when I first moved out there, and it hasn't done that in 18 years. And that's the time period that I've watched it year over year, come to the highest point during the winter and go to the lowest point during the summer. And never once has that area where that shop is near had water that's come up to it or near it. So that's one aspect. And then the other one is that pond behind our house has never been an active water body since I've been there. It's always been more of a still pond until you hit the winter. It'll, of course, fill up, and then it degresses back down to very minimal during the summer months. Well, that being said, it seemed like the most logical place to put that dwelling when it started, and the intent was solely for a shop to help store items and occasionally people if needed to be a part of our family during that COVID session, and that's how this whole thing began. And I know that there's not been one time that she's wanted to deviate from getting this done correctly or going through all the process with it 100% above board. And I know that that's been our heartfelt desire to do for this process and get that shop permitted. And so I really appreciate you guys taking the time to look at this, and I hope you get to see all the evidence that shows where the water bodies were and where they are now from 20 years ago, because I think it'll help you make that decision. And thank you.
Okay, thank you very much. Okay, so now we will have neutral parties. Do we have any neutral parties? Oh, I'm sorry, Tanya, you want to check online, see if we have anybody in favor?
Sure. If you're attending today virtually and would like to give comment in favor, please raise your virtual hand. I do not see any virtual hands raised, Chair.
Okay, Rio, do we have opposed to the application? Okay, thank you. First up, we have a Lori Siegel. Your 3 minutes will start when you come to the podium and speak your name, please. No, we do in person first. Thank you. This is persons opposed to the application, and we do in person first. So if you would like to forego your time, I can move on to the next one.
Get a waiver? Mr. Reeder was confused about why there'd be any kind of density standard, even though you've made your political decision for King. But there is a provision in the Oregon Administrative Rules that he's aware of. It's under 660, 033, 0130, sub 3, sub F. I won't pretend to be an attorney and start reading you anything like that. Just to know that it's there, it's about density, it's about an EFU zone, and it's about dwellings. So there was a complete roadmap in the record that the applicant could have followed to build her dwelling without a permit and have it be built to code as was stated earlier. That roadmap is for her other tax lot, 2201. Both tax lots were conveyed to the applicant in 2010, the same years, a few months apart. She was conveyed 1/3 interest from her father. The tax lot that has the dwelling on it was originally applied for by Mr. Palmer. Mr. Palmer wanted a non-farm dwelling. He didn't build it first. He was denied all along the way for most of the same reasons that apply today: the floodway, the floodplain. The agencies that participated, FEMA, DSL, ODF&W, and of course Lane County. In the end, the decision was appealed to the hearing official. The hearing official had 4 approvals that he issued for the application. The dwelling was required to be put up on pilings which was not part of the original plan and which was why it was denied. The driveway, the application, the permit history record for tax lot 2201 owned by the applicant shows that the access road from the south was built before the land use laws went into effect. The hearing official approved it as a non-conforming use. There are a lot of comments in the record about its effect on backwater flow, its negative effect on backwater flow. But in that permit file history, it lays out exactly what the applicant could have done to get this dwelling approved by the county legally. It's all right there. Thank you.
Okay, thank you very much. Next up, we have Joe Stack. Your 3 minutes will start when you state your name.
Joe Stack, Oregon Department of Fish and Wildlife. I am the regional habitat biologist for the South Willamette. So not only Lane County, but I cover Marion County, Lane County, Benton County, and Polk County. I'm here today to talk on several resource concerns associated with the proposed non-farm dwelling on tax lot 2000 for file number 509 PA 2405360. I will say I had a lot of stuff written here, but I think it's easier to go off cuff here. With the resource concerns here, you have the applicant kind of stating this thing as a pond. There's flowing water in the system. That's why I thought it was important for ODFW to get out there for the question here. With that, we took an electric shocker like we do with most water bodies to test this, and we found fish. And those fish exist in that system. They go upstream. Those juveniles, it's very important for them. It's kind of, the debate here is one calling it a pond, one calling it a stream, a channel. It's the same thing. It's not, I wouldn't say it's not a pond because you have flowing water, you have connection, you have fish that are moving into that system. So, I think the applicant did a good job of, you guys have heard the class 1 stream designation stuff, that's all on the record here. With that, I think that one thing that the applicant's representatives claim that the channel dissipates into shallower features, ponds, and wetlands, and therefore is not subject to the riparian setback area. However, when you look at Oregon administrative rules, that's going to define a stream as any channel that carries flowing surface water during any portion of the year. So as noted in that email that I sent to you all this morning, wild spring chinook were observed, which are a state and federally listed species. The presence of that fish at any time of year confirms the fish use and supports the Class 1 designation. After reviewing the May 11, 2026 letter submitted by the applicant's consultant, Wetlands and Wildlife, Inc., ODFW found several key assertions to be inconsistent with site conditions and with the regulatory water classifications outlined in Oregon Administrative Rule. Under the correct regulatory framework, the feature remains a Class 1 stream, not a wetland, and staff's measurement of riparian setbacks is accurate. And I think, real quick, ODFW is not opposed to development in the county. We're looking for responsibly sited development where people can coexist with wildlife, with fish, with natural resources. Thank you.
Okay, thank you. Gwen Farnsworth, you're next. Your 3 minutes will start when you get to the podium and state your name.
I'm Gwen Farnsworth. Every time I go to California, I'm shocked by how many $1 million homes are built on the wrong side of the levees and wonder who pays when they are inevitably flooded. Thankfully, Lane County does not fence off our rivers in that way, but it sure does allow a lot of building in the riparian zones. The original house on the border of the subject property was supposedly built on pilings 4 feet above the maximum flood elevation, so probably wasn't damaged in the 2 major floods and several minor ones since 1985. However, now there are 2 other large buildings and a few sheds on the same complex, some of which are on the subject property. Are they also on pilings so they don't interfere with the water flow? And what is in those buildings? A lot of the damage from floods is caused by debris and harmful chemicals washed out of human habitations. Do the unpermitted buildings have legal inspected electrical service? I think they covered that. It's probably has been inspected and it's probably okay, but I was curious about that. Electric lines can cause wildfires if not properly installed and maintained. What about septic connections? The original 1984 septic permit was for one 1,440 square foot house. Can it handle whatever has been added to it? The purpose of a riparian area is to allow a river to spread naturally. Testimony was given in the 1980s that vegetation would be removed and kept clear to permit faster water flow and prevent backflow. But vegetation, unlike buildings, slows water and collects debris, which protects downriver land without causing backflow damage to upriver. Please confirm the hearing official's decision affirming the planning director's denial of a non-dwelling on non-high-value soils in the EFU. Thank you.
Okay, thank you for your public testimony. Ms. Ellis, do we have anybody online?
We do. I see a couple hands raised, but I'll do one more call. If you want to give opposition testimony, please raise your virtual hand. Sean Malone, would you like to be on camera?
Yes.
I'm going to change you to a presenter. You should have received a request. Okay, and go ahead and turn on your camera. Okay, you may begin your 3-minute comment.
Good afternoon, Sean Malone on behalf of Landwatch Lane County. I see that I'm limited to 3 minutes despite the fact that both Mr. Reeder and Ms. Jones-McCann were unlimited in their time. It's virtually impossible to address any of what was said substantively in such a short amount of time. So I'll do my best, but it's impossible. I guess the first thing to address is that Ms. Jones-McCann named me by name and said that I was scared. I'm not scared at all because I have on my side the law and the truth, and you don't have to be scared in those instances. The next issue is Chapter 15. The way Lane County deals with amendments is it repeals and readopts in the entirety the entire chapter. That's a technical means by which to do it, and essentially, if you have a substantive amendment, then that's what is effectively changed. And Mr. Reeder hasn't identified any substantive amendments that from that Chapter 15 wholesale. Repeal and readoption, and so only those are the ones that were, only those provisions that were amended in that code are potentially no longer land use regulations. It's not the entire code. That's kind of a ridiculous allegation, and the board would do a great disservice to the entire county if it were to go along with Mr. Reeder's interpretation. Riparian setback issue, this one feels like Animal Farm. I have Orwell's Animal Farm. We have photographs of continuous flow. We have allegations that people have taken kayaks into this area. and we have found fish that would be going upstream and downstream in this alleged pond. So there's a lot of this, don't trust your eyes, trust what the applicant's experts are telling you. And so I think let's listen to our experts, our statewide experts, not our paid consultants. Let's listen to staff. And let's look at the photographs and use our eyes to do so and come to the conclusion that's contrary to what the applicant's saying here. As far as policy 11 goes, the county's interpretation of statewide planning goals must be consistent with Goal 5. And the county's not going to get deference to their interpretation of something that implements state law. So you've all been sold a bill of goods if you think that you're going to get deference in this interpretation of Policy 11. It's just not the case. And the simple fact is the density standard is enshrined in your comprehensive plan, as well as referred to in the working papers. And that density standard is what implements Goal 5 and ensures compliance with Goal 5. And if you get rid of that, you'll be overturned at LUBA and beyond that. And with that, please affirm the hearings official's decision.
Thank you for your public comment. I do see another hand raised. James, new, I have allowed you to talk, and would you like to be on camera? You are listed lines. Oh, there you are. Go ahead. Can you hear us?
Yes.
Okay. Would you like to be on camera, or do you want to just go ahead and go with your 3 minutes?
I'll just go ahead and go with my 3 minutes.
Okay, then you may begin.
Great. Commissioners, although it has been 6 years since the Holiday Farm fire, for those affected, it still feels like yesterday. The devastation, the loss of life and property, and the perseverance to rebuild property and lives continues. Many had to wait years to rebuild, requiring a great amount of patience with insurance companies, process coordination, and building plan check and permitting. But they persisted and were successful. Rules, procedures, and regulations were followed and adhered to, some grandfathering and system change, but they all followed county law and procedures. Today's hearing is about not following county law, ignoring procedure and regulations, dismissing the process, and violating state fishery habitat. Planning and building codes are in place and enforced to protect the public for health, safety, and environmental reasons. Without these protections, society would function in a chaotic and disruptive order. Lane County Commissioners are tasked with ensuring these processes are followed, enforced, and that nobody is above the law or that there are no conflicts of interest or favoritism. In today's case, where the county permitting processes were not applied for and building procedures were ignored, commissioners have a sworn responsibility to require county laws are enforced with penalty for disregard of these laws. To not administer a penalty and dismantle what was illegally constructed would send a message to all the people in the county that pulled building permits legally that they do not have to follow the law or rules and regulations adopted by the county. A commissioner's absolvement of the illegal construction would not only be a slap in the face to those residents who followed the law, but an example of the commissioners failing to protect the public. This also sends a message to county staff that rules and regulations that they are hired to follow and uphold does not have to be adhered to, and their duties are unenforceable. I hope you all understand the gravity of your decision regarding the egregious violation of the county building codes and required dismantling of the structural violation and a resubmittal for permitting. Thank you for the opportunity to speak.
Thank you for your public comment. I do not see any other hands raised, so I'll return it to you, Chair.
Okay, thank you, Ms. Ellis. All right, we're back to you. Do we have any additional comments or information in response to comments we've received?
I do have a few. Thank you, Chair.
Okay, excellent.
This is Norris Bradling again, Senior Planner. I would like to add briefly that during COVID, we did shut the office down for maybe 1 or 2 days, but then it was reopened and we were taking in business as usual as best we could. Well, do you want to add to that? You were there, Lindsay.
Apologies, Lindsay Eichner for staff. Our office was closed for a few days, and then we were open by email and phone after that for a number of months before we physically reopened the office. But we had staff working and responding to emails and phone calls, and we also had a developed a way for people to drop off paper plans and things. So I just wanted to clarify, we were not closed for months and months to the public.
Thank you. I'm going to briefly go through a response for each of the issues of the denial in the hearing's official decision. And you guys are welcome to, if you have any questions, to go ahead and ask. So I'm going to take you on a policy walk for the riparian regulations and how we understand them through the working papers. And I am going to use Joe Stack's submittal as examples of how this plays out in real life. So in the working papers, the flora and fauna working papers that were dated March of 1982, on page 20, there is a section that goes over how we look at sensitive fish and waterfowl areas. Midway through this page, it reads, portions of the following streams are sensitive fish habitat. And then it gives us a list of the sensitive fish habitat, and it's just a list. This list was updated in the addendum to the working papers, dated November 1983.
What was the date on that again? Say
It
again.
was amended. The list itself that was originally in the working papers was amended in the addendum.
And that you said a year, though.
Oh, 1983.
Thank you.
So the addendum lists revisions, and under revisions to the flora and fauna working paper, section 2 working paper revisions, subsection B, it reads, delete the list of sensitive fish habitats, which appears in pages 20 and 21 of the working paper, and add the more detailed list below. So this gives us a couple of pages of what the working papers decided should be the list of sensitive fish habitats. And on the last page of this, we have listed the McKenzie River from the county line to the main stem of the Willamette River. So here we have the McKenzie from the county line to the main stem of the Willamette is considered sensitive fish habitat. Further, on page 5 of the addendum, going down to subsection D, going down to subsection E, we're deleting a section of the sensitive fish and waterfowl areas and adding the following language. The Oregon Fish and Wildlife Department has recommended building setbacks of 50 to 100 feet, depending on the zone, which in turn reflects locations, along waterways designated as sensitive fish habitat. So here we have ODF's recommendation of the riparian setbacks being applied to sensitive fish habitats. And we have the designation of the McKenzie River from the county line to the main stem of the Willamette. This property occurs in this area. And as we've seen from the evidence submitted by ODF&W, there are sensitive habitat in this location. There's sensitive fish species that originate in these backwaters and migrate to the main stem of the McKenzie River. So we know that there's connectivity, both for the habitat continuance of the species of salmon that are sensitive fish that are listed into this backwater area, this backwater channel. So there's our policy walk of why the riparian regulations should be applied in this location.
Real quick, Norrie, so
Yes.
that whole policy walk was based off of a recommendation from one ODF&W employee? The policy was adopted by Lane County through the working papers in consultation with ODF&W. The evidence example that we have that connectivity, that this is part of the McKenzie and that sensitive fish habitat. We've seen how that plays out in real life, and the sensitive fish that are protected are located in this location. So that's that draw that this is part of the McKenzie's sensitive fish wildlife area. Okay.
Does that make sense?
It does, yeah. That seems like a long ways to go from moving a setback from 50 feet to 100 feet.
That is discussed further in the riparian working papers, the flora and fauna working papers. There's a whole discussion on that recommendation. It occurs pretty frequently in there. And I will say that we have adopted that into every section of our code, or our land use codes. So we are working right now with this application only in Chapter 16.2.1, subsection 2.1.2 for the exclusive farm use zone, and in the other zoning that is referenced within that. So if we go to Chapter 16.2.1.2 into the siting standards, there's the reference to the riparian regulations. And it's written directly into 16.2.1.2 that setback is 100 feet, and that's how it was adopted. It's similar to the rural residential zone. So if you look at Chapter 16, subsection 290 for the rural residential, in the siting standards, we also talk about the riparian setback area, and it's listed specifically to be 50 feet. So if we wanted to change that, we would have to amend all of those codes to say a different number. And we'd have to go back to Chapter 16.253 for the riparian regulations, where they're spelled out in more detail, to amend that as well. Because all throughout Chapter 16, wherever we have zoning that talks to the riparian setback area, we give that specific number.
Each time you say 50 feet.
It's 50 feet in developed and committed areas, and that's discussed in the working paper. It's 100 feet in resource zones, like the exclusive farm use or the natural resource area. It's actually 75 feet in areas where it's within the metropolitan area plan. So it is spelled out for each of the zones what that setback should be.
And I'm sorry, I missed what year did we change that to building codes? From 50 to 100?
I don't think we changed it.
Okay.
I think when we set up the riparian regulations, that was part of that initial determination. That's why it's discussed in the working papers, because the working papers basically told us as the county what we should be setting those setbacks at, that we should have setbacks, and then what they should be.
Okay. Sorry, anybody else? Okay.
Okay, and then Mr. Reeder was curious about how I mapped the area on the actual habitat mapping that was done. So back in May 21st, 2025, I submitted an open record memo to the hearings official where I originally did this mapping. So what I did was I did not map the habitat on the Lane County GIS mapping. I mapped it to scale, to the scale that the original map was done at, to show where the property was at the appropriate scale, mapped to the appropriate scale. Attached to my Exhibit D of my open record memo is a document from the U.S. Department of Interior, U.S. Geological Survey and Earth Sciences, so the USGS, on why it's important to use the correct scale when you are mapping things, especially development. So I'll leave that in the record if you guys would like to read through that. But it is important because when you are mapping things at an inappropriate scale, there is a lot of room for mapping errors to occur. We do this on a very regular basis for our floodplain mapping. FEMA, the Federal Emergency Management Agency, has directed us and trained us in how to map development on properties to the scales that the FEMA's maps are drawn to, the national insurance agencies. So it's really important for us to be as accurate as possible. And if you're mapping to an incorrect scale, you're increasing your inaccuracies. On the subject of Chapter 15, we've discussed this matter with County Council, and we do think that it went through the correct processes. If the board does not agree with that, it would not preclude the applicant from having to demonstrate compliance with Land Use Goal 12 for transportation. So that would be something that they would still need to prove up on, but that would be more part of the building permit process. Now, that being said, there are still aspects of the land use code that they would still have to show compliance with, and they have not done so. One of those is whether or not the location where they would be siting the bridge would be within a Class 1 stream. Now, this is not the same area where we measured the Class 1 stream from for the buildings. This is actually quite a bit to the north and west. This is the exact same location where a prior property owner had also proposed to site the bridge access for the dwelling, the non-farm dwelling that was previously discussed by the agent. And one of the reasons why that was denied was because that access, they determined, probably would have been within the riparian setback area. And that's the discussion that's actually attached to Joe Stack's submittal, was that the determination that that bridge would be located in that area. In addition to this, the applicant has not shown that the construction of such a bridge could occur within the easement area of the portion of the bridge that would be occurring on someone else's property, that property that's there to the north where the access easement comes through. The footing of the bridge, the bents, the foundation, that would all have to fit within that area. And as we've seen from the application, this area is mostly composed of river rock. So it's not the sturdiest area to be constructing a bridge in, especially a bridge that has to be able to accommodate a fully loaded water truck from the fire department. So we've not seen any examples or any as-built or not. We haven't seen any engineering drawings of what this bridge would look like. I don't doubt that a bridge could be built here. I've seen bridges built all over the place. It's amazing. But the question is, can the bridge fit within the easement area? And during construction, could it be constructed within this easement area, considering that that property owner who the easement area crosses has not shown that they are in their approval of the application? They have some major concerns. So you need area to construct a bridge, and do they have enough area even for construction? Those have not been addressed by the applicant. And then on the subject of Goal 5 with the Policy 11, we haven't had a chance to go through the tentative findings that the applicant has submitted. I do know that the first round of findings that the applicant submitted were not ones that were approved by County Council. So we would have to go through those. The hearings official declined to interpret the findings that were presented by the applicant during the hearings process because he did not think it was appropriate for him to be making an interpretation off of a tentative approval. It might have been a different matter if it had been adopted, but at the time he did not think it was really appropriate for him to be doing that. So I think yes, the applicant also brought up the issue of the floodway. That is Chapter 16-244. That is not a criteria of approval for this application, and he has not submitted an application to address that criteria. I honestly do not know that at this late a point in time, if that would be something that we could include in our considerations. It was an issue I brought up a very long time ago when he first applied for this application of what the plan was for addressing this issue. And it was never addressed. That is all that I have to say, unless you guys have any other questions.
I don't have any for you at this time. Commissioner Farr.
My questions are kind of vague at this point, but I want to say you did a very good job of explaining your process and responding to the applicant's concerns. I'm not sure that you've fully answered my questions that have been raised. But I have questions about the Chinook salmon habitat in what's called the pond or the flowing stream or whatever you want to call it. And that's the report, the walkthrough report that you have in front of you, is that right? That's included in there, the one from Mr. Stat?
Yes, that was forwarded to the county commissioners and to all the parties, so everyone should have access to that.
So it states that there are Chinook salmon in there?
Yes, and there is photo
You've
evidence.
actually seen the smolt in there, but no adults Chinook salmon in there?
And that's pretty typical of these backwater areas. The adults usually migrate into the main stem channel. As Joe Stack has previously attested to, these backwater channels are oftentimes used by the juveniles as they grow because there is better food sources for them, and there's a greater reduction of predation in these backwater channels. Those larger fish just can't get up through there. It tends to be.
I'm pretty familiar with the Springer Run on the Mackenzie River. So the adults don't spawn in there, but the juvenile use it as resting area or feeding area on their migration to the ocean from the spawning ground. And they don't get trapped in there. I didn't hear that I heard that there's flow in, but not necessarily flow out.
They can go, so there's a continuation of water, so they can go back and forth as long as there's that continuation of water.
And this is in June-ish that this happens, late May, June?
When I was out there on site, I think it was in September, there was water present.
Okay. In September, okay. Did you see any kayaks? I hear kayaks go in there.
No.
Can you jump to the part in the report where it says kayaks have been seen in there?
I believe during I think it was during the open record period for the hearings official, was a submission by Joe Stack of going up as far as they could in the kayak.
Into that pond?
I don't think they made it all the way into the pond.
I'm really confused by that testimony. Okay, go ahead. That's fine, that's enough, thank you.
Chair, I'm still not clear if the pond is connected to the river, which got the smolt into the pond. I haven't heard a definitive answer to that yet. Am I missing something?
Yes, so in the submittal by Joe Stack today, there is a map of where he found the Chinook.
I understand that, but I'm wondering if where the connection from the main river where you're saying that these smolt come from into the pond, according to the applicant, that connection hasn't been made in 18 years. So I'm wondering if there's any evidence that we have that you know of, other than just subsequent or hearsay, that they're there because it was connected and it hasn't made a connection. So I'm confused if there's actually a connection that's been made.
Yeah, the connection area was the location where the Chinook salmon were found.
In the pond, we're talking by the garage shed that the applicant has. Is that what we're talking? One that's just to the northwest?
The salmon were not found in the pond, in that backwater area by where we measured the riparian from. The Chinook were found in the connection area between where the standing water is that you can see in most of the aerial photos and where the standing water is next to the applicant's non-farm dwelling.
So then you're saying that because that connection's been made as, let's just call it an arm up into the property, that affects the 100-foot setback more so than what the applicant is claiming? Is that what I'm understanding?
That is why we are considering this part of the McKenzie River.
Okay, you didn't answer my question. What we're talking about is a 100-foot setback here.
Yes.
Okay, so I'm wanting to know where that was determined from. According to the applicant, it's determined from one point, and I'm hearing from you that it may be determined from another point. Am I missing something?
Lane code has it spells out in lane code how we determine the ordinary high water, and that from that point of where the ordinary high water is where we measure the setback from. The argument is not whether or not the setback was appropriately measured. The argument is from the applicant is that we did not measure determine the ordinary high water mark from the correct class 1 stream. So the ordinary high water mark is determined based on the presence of certain plant species that are adapted to living in inundation by water, and by markings on of how the shelving happens when the water erodes part of the stream bank, and whether or not there is a presence of debris where water pushes up the debris from the flow onto land. Those are a few that I can remember off the top of my head of how we determine that. And then from where we determine that ordinary high water mark, that's where we begin measuring the setback. And in this case, because they're exclusive farm use zone, that setback is 100 feet per lane code.
So how close are they?
I have a very small picture from my riparian declaration. All of the outbuilding to the north is within it. All of the propane sheds they constructed later in time is within it. And about half of the non-farm dwelling, roughly half of the non-farm dwelling is within it.
When you say within, it's closer than 100 feet?
Yes.
Just for clarity, okay.
Yes. And that's in the record. So that was on the slides that I provided. And I think it's in the staff report. So if everything had been shifted further out, they would have been out.
My question is still how far? I mean, when you made it a point already to tell us that, we needed to use the right map with the right scale.
Yes.
I want to get the right scale and the right measurements in my mind because it was really hard to determine from materials that were provided.
Mm-hmm. So if you wanted to go off, I could remap it if you would like, to determine based on the habitat maps that were adopted that are at a scale of 1 inch equals 1 mile. I could see if I could determine how much of the development occurs within the area. I would also say that the way I understand the working papers, the black lines are actually the riparian habitat that's around the class 1 streams and not the class 1 streams themselves. But if you would like me to provide that, I can provide that based on the actual to scale mapping of how much of their development would be within that riparian area.
I'm going to hold off on that answer, thanks.
Yeah, I know, I was pondering the same question. I mean, is it less than 50 feet?
Well, just on looking at the actual scaled mapping, I would say probably all of it, but I would have to map it out specifically. We would be open to an open record period if you guys wanted to grant that, and I could provide it.
Open record, we have plenty of material. Please.
I'm still puzzled about the Chinook salmon. I'm looking at the satellite map of it. And I can see downstream, was it downstream of the pond where the Chinook salmon have been seen, or upstream of the pond, or can you tell me?
It was, so if you're looking at the satellite map, we've got the larger area that is the section at the very end that's next to the development. And you can see that on the, coming up from the McKenzie River, there's a pretty clear upstream channel, the back channel that comes in. And there's a little pinch point where you don't see, there's a lot of growth right there. There's a lot of plant material, so it
There's
turns
kind of
green.
an offshore island right there, okay.
And it's in that area that the Chinook were found.
Up, way up there. But no further downstream, not in the pond by any stretch of the imagination then, but just up in that little pinch point you call it. Okay.
Yes.
All right, okay. Seems kind of remote to me, but okay.
That's in the furthest south area of lot 1904. Is that what you're saying? Just so I'm looking at the right pinch point?
That was my interpretation.
I don't think the pinch point is actually on this.
The pinch point is closer to 1905.
So it's at the,
Same location where the proposed bridge easement area would go.
so you're saying from that area where the proposed bridge is to the structure in question is less than 100 feet?
No.
No. That would be where the bridge would be located. So if the applicant wanted to go down the route of applying for a bridge in that location, they would cross that, and we would probably consider it a Class 1 stream as well, considering that we consider this lower section, this lower arm of the backwater. And it's sensitive fish habitats.
Anything more for staff? Okay. Final rebuttal?
Chair Senega, Commissioners, for the record, Mike Reeder for the applicant. Just want to answer first Commissioner Lovell's question about how far away the shop with the single-family living area up above is from the ordinary high water mark. In the record of Agenda Item 7A, page 122 of 707 of your agenda packet shows a site plan, and the dimensions are that it is the closest portion, the closest corner would be the northeast corner of that dwelling is 97 feet from the ordinary high water mark. The outbuilding is 93 feet from the ordinary high water mark. If you were to assume that that ordinary high water mark was a designated Class 1 stream, which it's not, okay? So just to answer that particular question. Okay. So I want to address a couple of things regarding staff's comments first. The fact that the LMD offices were closed for a couple of days, and then you had to reach someone via email or over the phone. It's not an excuse. It's not a get out of jail free card for people who develop without going through the proper process. My client wasn't asserting that. She was giving explanation and rationale for why she did what she did. She wasn't saying that relieves her from the obligation of going through the process now. I think we've all been in situations where we've violated law, maybe that's a speeding ticket or a parking ticket, and it doesn't mean it's the end of the world. It just means we have to take care of it. That's what we're here for, is to take care of it. In regards to the non-farm dwelling criteria, the non-farm dwelling criteria, the hearings official should not have denied the application even if you believe that the pond is part of the McKenzie River somehow and therefore designated as a Class 1 stream, there are varying levels of arguments here. We hired Brian Meyering, who's not a hired gun. He's a consultant with a good reputation, and I told him, don't give me a predetermined outcome. Just go do your job. Tell me what you think, and that's what he did. Okay, and he's here to answer any questions you might have, but his written material is in the record. It is the pond is not hydrologically connected to the McKenzie River. The location identified by Mr. Stack in his material today shows a red dot on property that is not part of the riparian area that staff has identified. That's further down. With regards to a bridge, I testified about this. Perhaps County Council can weigh in either now or later, but we have a right to access. It doesn't matter whether there's a regulation that protects this backwater or pond. That regulation must be ignored in order for my client to be able to obtain access to that lot. Now, we may be confused because she owns two properties, right? She owns the property that she lives in, which is a discrete unit of land. It's its own unit of land. You look at that in a different universe. The subject property that's here before you today, it must have its own access, and it doesn't have access from the south. She can't grant it because she doesn't have that right. She has the right of access across that pond. And the Constitution says that she has that right of access, regardless of what the code says. The Oregon Supreme Court, and I've provided that to you in the record, the citation where the Supreme Court says that access is it's a property interest that cannot be taken away, regardless, whether it's through the code, whether through the comprehensive plan, that they have to have reasonable access. And that is the law from the Oregon Supreme Court. So it doesn't matter. It doesn't matter that this particular building may or may not be within the 100-foot setback. We say that it's not, but a non-farm dwelling application isn't set for just the location, the footprint of what has been built now. The client could have if she wanted to, go through the demolition process, remove the house, and build somewhere else. The application is for a non-farm dwelling. Regardless of whether or not there's sensitive fish, it doesn't matter. The county went through a process, a Goal 5 process. That Goal 5 process requires certainty. The case that I provided to you in the written material, I think, is really helpful because you don't need to get bogged down in whether Joe Stack found a sensitive species in either the pond or a section of the pond that's not the pond that was identified by Lane County staff or not. It doesn't matter because the mapping has to be definite. Now, I heard Nare talk about, well, I did this analysis. I took the map and I scaled it, and this is what it shows. Well, I'm sorry, that's not how land use works. And there's case law that says, in fact, it's with the city of Eugene, we've got a blob map, okay? I went to LCOG when I was a brand new lawyer, came to Eugene. I wanted to see what the Metro Plan, I needed a copy of the Metro Plan. So they give me this 11 by 17 blob map showing the location, the locations of the comprehensive plan areas. Well, it's a blob. It's not parcel specific. And so I said, well, hey, LCOG, can you blow this up? Can you make it tax lot specific? And it took months for me through public records requests to get LCOG to make a map, to use their polygons to do a parcel-specific map for me and overlay the blob map on there so that we could look at where that line is, where the zone is. Well, in like manner, the reason why LCOG didn't want to do that is because case law says from LUBA, and I believe the Court of Appeals, but LUBA says you don't enlarge the map. The map, the adopted map is the adopted map, whatever the size is. So you don't get to do what Norray said she did. And what we did was we took the map that's available to Joe P. Public, the GIS map that's available, and we provided the maps that show that the designated Class 1 stream is located on the property on the west, not on the east, which is where her map suggests that it does. Now, this is important. So this case, I provided to you the citation. It's Nieder versus City of Albany. I'm sorry, wrong case. Sorry, there's too many cases. It's let me get there because it's important. Regarding mapping. So the mapping needs to be definite. Now, it doesn't have to be perfect. That's not what the case law says, but it needs to be definite enough that a person can identify the zone, okay? And this is in regards to big game range as well. Okay. It's the Realty Investment Company case. Apologize for that. Okay. In regards to big game range, this big game range minimum acreage standard for EFU generally and non-farm dwellings specifically, there must be a compelling and reasonable explanation for why the standard is being imposed. And I cite the Nectow versus Village of Euclid Ambler Realty case. And then it says, the court has held that zoning regulations may be determined to be invalid as applied to a particular property when the regulation, quote, has no foundation in reason and is a mere arbitrary or irrational exercise of power having no substantial relation to the public health, public morals, and public safety, or of the public welfare in the proper sense. And that's a Luba case from a long time ago, back in 1981, where Luba was grappling with these property rights issues. And they cited Fasano for that standard, for that legal standard. But that case that's cited, that 1981 Luba case, also talks about mapping. And what Luba did was they struck down the city of Gresham's map where they had done a very similar thing. They had used a Sharpie and it was indefinite. It was very difficult to determine where the zoning district ended and where it stopped. And Luba said that's invalid. Here we have staff saying they had to go through an elaborate process to use, I'm not sure what the method was that they used to size it to find out exactly where this stream is. Well, I'm sorry, that's not how land use works. You have to have an inventory that is discernible and understandable for the common person. And we're struggling with it here as, professional planners, lawyers, now the Board of Commissioners. It's simply not there. And if the county wants to use 2026 technology and go through the process of inventorying these Class 1 streams where they think it is, then that is their prerogative. But the county has not done that. We don't go to battle with the army that we have. We go to battle with the army that we wish we have. We go to battle with the army that we have. And this is what we have. And yeah, it's old. It's archaic, but that's planning. You don't get to change the rules of the game ad hoc, which is what's happening here and what my client has been subjected to. There is evidence in the record from Miller Consulting, our structural engineer, showing that it is feasible to build the bridge without even impacting the stream, whether it's considered designated protected Class 1 stream or not. So we have an engineer that's in the record from them. So don't want to ignore that. Joe Stack testified about the fact that there are resource concerns, that they found a fish, and that state law defines Class 1 streams. Well, that's irrelevant. It's not state law that controls, it's the local rural comprehensive plan that designates the Class 1 streams. So the state can define what a Class 1 stream is, that's fine. Just like DSL and the Army Corps of Engineers can define what a jurisdictional wetland is. But under the Goal 5 scheme, just like with wetlands, you may have wetlands that you have to get a fill permit from the Army Corps of Engineers or DSL, and they're protected in that way. When you go through the Goal 5 process as a local government, you have to inventory and identify with specificity what that designated Class 1 stream is. And when you have a map that shows Class 1 streams that are protected and then it stops, and then you have a thin line where it's not, that has to have meaning. Oregon law requires that you give meaning to all law, whether it's a map or whether it's text. So you can't say that we protect our streams and by designating them and say, well, all Class 1 streams are designated for protection. That violates state law as well. So I'm about done. I just want to make sure I haven't missed anything. And I'd be happy to answer any questions that the commissioners may have.
I had one from earlier.
Could I interrupt for just 1 second, Chair? I apologize. I asked and then I recalled. To answer the specific, respond in detail to what has been testified today by staff, if you go to the June 4th, 2005 letter from Lanphier Consulting to me, that's in the record, that will address and respond to everything that's been raised today. So I'm not going to sit here and do that today. It would just take too much time, and I can see people, we want to do other things. But that is in the record. All of those issues that we've talked about are in the record. So if we were to close the record today, I am confident that if you approve this and you adopt the findings that we've provided to you, that it would be upheld at LUBA and the Court of Appeals. I don't have any concerns about the testimony that we've received today. It's not testimony that I feel like the record needs to remain open because it's all in the record. We've been belaboring this for a long time, and it just requires correct interpretation by this board. I'm sorry, I interrupted you, Chair Senega.
No, that was actually where I was going, was with findings and so on and so forth. I mean, because I don't know how many pages we're at now, but, you know, I just keep simplifying and simplifying and simplifying to get to yes or no on basically what I've come down to 4 different concerns. And I wrote a note down earlier. Have you ever seen the big game overlay applied to EFU?
No.
In 40 years?
No, and I have not done a public records request, but I can be as sure as I can be without actually doing a public records request that it has never been applied. Just like it was never applied in the forest zone prior to NIMCISH.
And Kevin McCormick, the bridge engineer, was on site and said he could build a bridge within.
Yes, he was on site, and he also inspected the building. So I apologize, this is something I did not respond to, but people were in opposition talking about how the 1985 home that was built with permits is on stilts. Well, he also did the analysis to show that the building as constructed without permits, it can meet the county's requirements for floodway. If you were to approve it, he is confident that when we go back for building permits, that with few modifications, it would meet the county standards. It doesn't need to be on stilts because of the elevation.
Okay, those were my only lasting 2 concerns. Thank you.
Thank you.
Commissioner Farr.
I have just a couple of quick questions, and I'm looking at both the satellite map and this map right here. I'm presuming that the dwellings, which are 88, 184, 144, 88, 064, 056, those are all rural residential. and they're directly adjacent to this EFU property.
Correct.
And it seems a little bit arbitrary. Now, the line has to be drawn someplace, right? But it seems really vague at this point in time why the line would be drawn there, other than it kind of follows that swale, the swale that goes down to the pond. Okay. Okay. So the very close by, the 88080, is that rural residential or is that the EFU? That is,
Commissioner Farr, I'm going to have to.
that is this one right
I don't have
here.
enough.
That one right there.
No, that is the applicant's.
That's the principal dwelling.
Permitted dwelling, correct, which is EFU, and received a non-farm dwelling approval.
All right, very good. Well, thanks for the information, and thank you for your professional work and really explaining it as well as you could to somebody who does this a few hours every year or 2 years, and you do it for a living. You do it every 8 hours a day, presumably, and it's hard to get people to understand exactly why things are the way they are, and especially when it feels really quite arbitrary, some of the applications that have been put into place for this particular application. My inclination is to uphold the application and ask for staff to apply the findings that have been presented to us, and then move forward with the move toward permitting. So that's my inclination at this point in time.
If there's no other questions for me, I'm happy to step down.
Looking at Vice Chair, seeing none. Commissioner Lovell?
I just have a kind of maybe get in my head kind of question. As I'm looking at this map right here, does the Mackenzie River flow west to east on this bottom section?
No.
Does it flow the opposite way?
Commissioner Lovell, no.
Right here, this part right here. Does it flow, because we're pointing north on this map, does this flow west to east, or does it flow this way? That's my question.
It's east to west.
Yeah, east to
It
west.
flows east to west.
Correct.
So it goes around this horn, and then this backwater channel is, okay,
Yeah.
that's what I need to know. Thanks.
Further questions?
Thank you, Commissioners.
Okay, well, if nobody's opposed, we can close the hearing. Okay, the hearing is now closed. There's been no request that the evidentiary record be left open, so the record is now closed. It's time to deliberate. Is there any deliberations? Vice Chair.
Thank you. I wanted to go back to some of the opening comments regarding the impetus for building during this COVID time and just express some of my frustration. It feels like, it sounds like there was a contractor may have sold the applicant a story that, hey, you don't have to go in for the building permits. I'll build it for you, just take photos, and we'll get it approved after the fact. I don't know of any reputable contractor who would knowingly make that assertion to a potential client unless they were really looking for a job, which this may have been that case. I don't know. The contractors on the site had to have known that permits would have been required and should be applied for prior to building a building. And I find it particularly egregious for contractors to continue building knowing this fact. And I don't know what to do about that after the fact, other than I know the applicant likely knows who those contractors are. But that is I think, the beginning of this story. And the part that feels egregious is how much time and effort and cost it is to correct something like this well after the fact of a building being put up in a place where there are obvious issues for building. So I just want to share that particular frustration because a lot of this could have been avoided if it had been done with permits originally. And feels egregious to many people, including myself, when other people are going through the hoops of building a building, following all the rules and regulations, taking the time to do so, doing the right thing, and paying the right fees, the right time to get things done. But other people aren't doing that. I think that's part of the overall frustration the applicant may be feeling from the outside. And then this, I presumably, comes to us after the fact when a neighbor says, hey, I don't think that is supposed to be happening over there. Land management, please do something about it. And often then we find people in front of us, in front of the dais, as we are today, trying to sort out a big mess. So I just want to implore people, this is a prime example of what people should do to go through the correct process in building initially. I at least wanted to share that today. The applicant is there with us in the room, and this is highly watched. I don't know where the motion will go, but I'll wait to hear from my colleagues.
Thank you, Vice Chair. Anybody else? Commissioner Lovell?
Yeah, I'll take a stab at that. Thanks, Chair. This isn't an unusual situation. Unfortunately, as Commissioner Buck said, it is an emotional situation, but I think it's a repairable situation. Around the corner from my house, and maybe council, if I'm out of order talking about this, please stop me. Around the corner from my house, there was a major horse stadium built behind a person's house in the floodplain. It was painted white, and it looked like a major Hollywood set that Tom Cruise was on, and they were redirecting the sun into his face. It was so large. And it was built without a permit, and 700 tons of rock and cement were hauled into the floodplain. And the case was, the neighbors were saying, how does that not redirect the river if there's a flood on ordinary high water mark? And somehow, through the protests of the neighbors, even when I was helping, because I thought it was built egregiously as well, that got permitted and approved. And so now I have a major horse arena stadium a block from my house that's between my home and the river that is legally permitted after the fact. In fact, it had an apartment planned in it, and that too is permitted after the fact, which staggers my imagination. So I'm wondering, as my questioning was about this, here we are, we're talking about something that's 3 feet, maybe 5 feet within the setback arena, that it feels like we're splitting hairs here. It feels like there's a path forward that the applicant can make the corrections, pay the appropriate permits, fines, whatever is necessary, and be included in what Commissioner Farr says is maybe a more equitable fashion of measurement that the other properties around it that are within a 50-foot range. This is now the only one that I can identify that's been identified in this hearing as a 100-foot range. Seems to me like there's a happy medium here that could happen. And I would be in support of the applicant and the presentation that Mr. Reeder had made to support reparations and the findings, and if there's some modifications, I'm assuming Mr. Reeder's talking about foundational modifications where flow passes through. They have to have a certain amount of holes or fallouts within the foundation that doesn't harm the structure integrity. I assume that's probably going to be some modifications that are going to have to be made. But I think this is a path we could take. And as I've stated before, as a county commissioner and a land developer, I will always stand for my constituents to use the land in the value that they've been paying for and the taxation that we've been extrapolating as a county. So that's my thoughts.
Thank you. Commissioner Farr.
As I've stated, I'm inclined to agree with the upholding the application and produce or write findings consistent with the presentation that's been made by the applicant. Now, I have a couple of questions on that, but also the process that we're going through. You know, we're stepping back in and fixing errors that have been made, whatever the cause may be. This is a single case, but it's representative of a number of cases. One that was just stated by the fellow commissioner. You kind of frown at me at that. Am I wrong in that?
Can you say that one more
Well,
time?
that similar processes this may be applicable to similar processes in the future where people are trying to rectify if they hadn't filed for a permit and going back to make it correcting whether it be missteps, whatever you may want to call it along the way. That's something that happens from time to time, clearly.
I'm a little, I will be frank, I'm a little concerned about the repercussions of changing the way that we interpret the Class 1 stream, ordinary high water mark, that process that we go through. This situation occurred because there is an extreme mismatching between where that mapped Class 1 stream is and on our GIS system and where the actual existing is. In the majority of cases throughout the county, there's not this egregious mismatch.
Okay.
It happens very rarely. And sometimes it actually happens in the favor of the property owner, where that Class 1 stream is mapped in an area and the actual stream is like way on the other side of their property, like hundreds of feet away. And if we were regulating off of just that map, we would have to restrict them more than we would if we had the flexibility of looking at the actual location.
Understood. Then,
and it just doesn't happen that often.
Okay. Thank you for that. And then, in that it doesn't happen very often, we do have a mismatch in this case, which doesn't occur as often. But we do have a mismatch in this case, which has been interpreted two different ways, one by the applicant and one by ultimately by the hearings official, with the evidence that they've used. And my point is that in this situation, I would like to move forward with upholding the application and adopting the findings that have been presented to us. And I'm going to presume that will be tested. This is a good case in point to test. And I think that, now, Lindsay, you frowned at me on that one.
Oh, no.
Okay, all right. I'm watching facial expressions because y'all do this for a living, and I'm more about. Most of our work is not specific to this on this particular level. So that being said, the applicant pays double the fees. Is that correct? In hindsight, somebody said that.
I'm not on that end.
Okay, all right. Well, anyway, then how do we move forward? Do I have a motion?
He just made one, it sounded like.
Okay.
Oh, yeah.
That's the option 3 is the motion then? Okay, then I will make sure those are my words. Okay.
Put your readers on there, Commissioner.
Okay, then my arms aren't quite long enough. Then I move not adopt the attached order and direct staff to return with a revised order reversing the hearings official's denial and conditionally approve the application with findings of fact that include the board's interpretation of Lane Code Chapter 16 and associated case law.
Second.
Speak to the motion.
Yes. You want me to repeat it real quick?
Yeah, go ahead.
Yeah, so we have a motion made by Commissioner Farr to move to not adopt the attached order and direct staff to return with the revised order reversing the hearing's official denial and conditionally approve the application with findings of fact that include the board's interpretation of Lane Code, Chapter 16 and associated case law. Seconded by Commissioner Lovell. Discussion.
Thank you. And I'd like to look staff right in the eye and say, good work. And on a regular basis, you do good work interpreting what is really quite convoluted in many, many cases, this being one of them, where we have two sets of evidence that have different conclusions. And in this point, the board, majority, or it's not been voted on yet, we're asking you to consider the other set of evidence and move forward with the next step in the process to determine whether or not which set of evidence is going to be the ultimate law that is applied. So I believe we're moving in the right direction with this, and I also believe that you've done superb work to get us to this point, so thank you.
Chair, point of order.
Yes, Mr.
Yeah, I just wanted to clarify that motion said findings, but it didn't specify that it was the findings that the applicant has drafted and submitted, and you may want to just change that to clarify that you're just going to adopt the findings that the applicant submitted.
Thank you, Council Davis. I almost did that, but I read it verbatim. But it was to I would include the findings as presented by the applicant.
Okay.
I'll second the revised motion.
Okay, we have a motion made and amended by Commissioner Farr, seconded by Commissioner Lovell. We're in discussion. Vice Chair, Commissioner Lovell.
Yeah, Chair, I want to also acknowledge the staff for all their hard work, and I know this is a really difficult thing to come to the board all the time, and when you have all this work and you have a case and you think you have a good case moving forward, and then it gets flipped around, and I also can identify with the applicants who come forward, and let's face it, I mean, by evidence, and I'm not criticizing anyone, by evidence, Lane County is the toughest county in the state to build in. And we need to change that. And I think there is a precedence for those who can stand and make these not necessarily nuanced cases, but the cases that would pertain and affect other folks within the county. When they have the means and the patience and the emotional stamina to do that, I think it's important that we flush those out to the fullest, because I think it's important that landowners in our county get to use their land as the value of their land that they bought and they're taxed on. That's what I keep coming back to. So, the reason I asked for the actual footages of why this was, if we're talking about 3 feet here, I don't think that's going to change the world in the big picture of things. I think, yeah, there's letters of the law, there's intentions of the law, there's arguments both ways, but I also think that we owe a service to our citizens to do the best we can to allow them to use their dreams and hopes and their value and their resources to the best they can. So that's where I stand on that, and I will vote in favor of this motion.
Okay, see nothing from Vice Chair.
Excuse me. Yeah, I was just chatting with the applicant's attorney. There's an issue that he wanted me to point out, that the findings that he submitted yesterday do not address the point that he requested of you to waive the 16-244 requirement. So, Mike, did you want to have them reopen the record and then you wanted to speak to that? Is that how you wanted to deal with that?
If the chair would like to reopen the hearing, I would speak to that.
It's already been spoken to, though, right?
Go ahead.
No, you.
Okay.
You could restate it again, that it doesn't, the findings zoning, they're missing something.
Yeah, so the findings, you don't need to reopen the hearing if you don't want to, but I think the statement by the applicant's attorney was that he drafted findings that were submitted, I think, yesterday, and those findings do not address the request that he made during his presentation about the fact that you would need to waive the 16-244, which is the floodplain requirement of the prohibition on development in the floodplain.
And thank you for that clarification. My intention was to include that in the motion, and I called it the findings. Clearly, there's a different word for it.
Okay, so do you think we need to go back?
So if I'm, just to be clear, the findings will actually be supplemented by Mr. Reeder here to to deal with that additional issue.
The additional testimony provided today prior to the closing of the public hearing, yes.
So we'll need a new submission from Mr. Reader to add that additional issue. And I hate to back you up, but we could have you make that motion or correct the motion and then second the friendly amendment to it.
Can I see the template again?
I think you could just. Like in Portuguese and Spanish.
So my motion is to not adopt the attached order and direct staff to return with a revised order reversing the hearing's official denial and conditionally approve the application with findings of fact that include presentations by the applicant and testimony provided today. And the board's implementation of Lane Code Chapter 16 and associated case law.
If it'd be okay, Commissioner, can I borrow that from you?
No, what I said has to be, no, yeah, please. Yeah, go ahead. You know, we so many things are ambiguous. Let's make this a little bit less so.
There you go.
Appreciate that opportunity. I think he does too, so.
Oh, he's got it written there.
Findings of fact. Could I just read this into the record and see if this fits everybody's needs?
Thank you.
The motion would be move to not adopt the attached order and direct staff to return with a revised order reversing the hearings official's denial and conditionally approve the application with findings of fact that include the board's interpretation of Lane Code Chapter 16 and waiving Lane Code Section 16.244 and associated case law to be submitted by applicant's attorney within 3 days.
3 days, okay. Cool. Yes, thank you, that is my motion.
I'll second the revised motion.
Okay, motion's been made and seconded. Any further discussion? Okay, seeing none, I just finished by also thanking staff. Ms. Sprawley, you did a great job. Ms. Eichner, thank you for bringing these things to us. As you can tell, it means a lot to the families to be heard by the people that are elected. And to the McCann Jones family, sorry, this turned into a villainizing. That doesn't make business easier, and it makes things more emotional than it needs to be. I'll call for a vote, if that's it. All those in favor signify with an aye.
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 Okay, motion carries 4-0.
No.
Oh, I thought you raised your hand to vote.
Well, I actually raised my hand before you called for the vote, but I had a concern. It may not be after the fact now, but was the waiver of the floodway part of the public notice for today?
Nope, it was not.
So does that have an effect on what we do with this particular motion?
Yeah, I do have some concerns about the 16-244 approach.
But it's the notice part of that concern.
What's that?
I think she's asking about the notice.
Yeah.
I'd sure love to have heard that before I made my motion.
Well, now that she's raised it, we could go back and address and talk about that, or you could move forward with your vote. Or just,
Vote's already taken.
no, that's what I mean, move forward as if.
We could unwind it, but
Yep.
the question is,
I guess I have a quick question for Mr. Reader, which is he concerned about the notice provision related to 16244? I didn't think so. He may have to defend that action.
I just want to make it clear for the record if, that I was a no vote on this.
Okay. Those opposed?
Nay.
Okay. All right, motion carries 3-1 with Commissioner Buck being nay and Commissioner Trieger absent, excused. Thank you. Okay, well, that will conclude everything for today. Thank you, everybody, for sticking this out. We will re-adjourn tomorrow at 9 a.m. in the BCC conference room.